Sam Seder on the Majority Report. Emma Vigeland out today. Joining me now, David Dayen, the executive editor of the American Prospect. David, welcome back to the program.
Thank you for having me on the program.
All right, let's start with this Google monopoly case, because it will help us lead into this conversation about Kamala Harris, the prospects of her sort of like adopting essentially the Biden administration anti-corporate stance, and whether Tim Walz is any indication as to what of what the likelihood of that is. But this Google thing is a big deal, isn't it?
Yeah, it was the first real major monopolization case in 25 years. And it turned out, at least at the preliminary level, the same way that the last one did, with Google being found guilty of being a monopoly that is using its market power in anti-competitive ways. It's many ways similar to the verdict in the Microsoft trial in the late 1990s. In fact, the judge used the Microsoft trial as precedent on many occasions throughout the very long, it's like 286-page verdict in the Google case. So these two were pretty analogous. Microsoft was accused of bundling its browser to muscle out competition from Netscape. Google is accused not just of bundling its search engine within its own browser, Chrome, but also of paying other companies to make its browser the default in Apple products, in Mozilla's Firefox browser, and in a bunch of other devices, including Android devices, which are part of the Google empire as well. So they're very similar cases, and at least at the district court level, they've reached similar conclusions.
Let's talk about, sort of some of the evidence of, or I should say, what is the standard? Like, I mean, they have essentially become, they're the, like 70% of all devices that exist, more.
The Google's market share is at 89.2% of all searches. And on mobile, it's more like 95% of all searches are done through Google. This particular way in which they have cemented their monopoly through buying access to the default browser or the default search engine on browsers and devices is responsible for about 50% of all searches, and another 20% is because they own Chrome and they just bundle their search engine within Chrome. So
there's 70%, they're the default search on 70% of essentially all devices that connect to the internet.
Right. And in the other 30, it's not like they give up competition there. They're working to get those, which is why their actual rates of market share in search is well above 70%.
So do they need to have been found to, let's say it was just like 90% of people decided to use Google, and there was no, because ultimately, let's just say just 90%, right. They never paid for $1 to be the default browser. They're not even the default browser. If 90%, would that have been enough, do you think, for the judge to find that they are an unfair monopoly?
Well, the bottom line is they did pay, and they paid a lot. They paid $26.3 billion in 2021.
Well, that's a lot to you.
Yeah, maybe not a lot to Google, to be the default search engine. And the way that Judge Mehta structured the case is he said, okay, is there a relevant market in general search? And he said, yes. And then he said, okay, is Google a monopoly in that? And he said, obviously. They have 89% of the market on desktop and 95% in mobile. And then he said, well, okay, it's not illegal to be a monopoly because of what you just said. Maybe they're just the superior product. But are they using that power in exclusionary ways? And the answer was yes, because these contracts that they have while technically not exclusive deals, are de facto exclusive deals because of the way that they are structured. Nobody else can give Apple or Mozilla the kind of money that Google is able to give. That's number one. So that forecloses the market. The second thing is that there's a network effect in search. The more data you get, the more queries you get, the better the search engine is. So it's tautological kind of to say that Google is a superior product, because the reason they're a superior product is because they're a monopoly. That's why they get more data from people. They hold on to it for 18 months, all of your searches, all of your information, and they use that to inform its search. And that's why it's a better search. So if they were giving these tools that they use to other search companies, then everybody could compete on search, but they can't. So because of the lock-in effect by this particular way in which they're buying access to defaults.
And they seem to have made like a half-hearted attempt to say, well, default doesn't mean anything, but there was so much documentation from their own internal economists. And it's also hard to argue that like there's no value to being default. That thing that we pay billions upon billions of dollars to secure is a tough argument to make.
Yeah, it was impossible to really square that circle. And you know, at one point, Judge Mehta in the verdict says, you know, he knew that Google was kind of dissembling on the stand around this. And he says in a footnote, he says, I'm going to take your internal documents as more important for this case than what you said on the stand. Basically, a veiled way of saying you were lying on the stand, saying that, look, this is what you said when you thought nobody was listening. And what you said was that defaults are really, really important, and we will pay as much as possible to keep other competing search engines out of that business.
I mean, if that judge was a little bit more ornery, or maybe just even like, I mean, frankly, it's hard to imagine a judge extending this type of charitable interpretations to other defendants in other contexts. That he's basically saying you lied on the stand, and B, you also got rid of a lot of evidence. You destroyed it, and he basically said, you still found guilty, so I'm not going to hold the hiding of evidence against you, which is, that's a pretty charitable thing to do, it seems to me.
He chose not to sanction them because it didn't matter, because he found them guilty anyway. That's right. And yeah, I think it was pretty charitable to say, you know, this massive years, maybe decades long burying of evidence so that you wouldn't get in trouble was no harm, no foul, because I was able to figure it out anyway. Yeah, that's I think charitable is one way to describe that. Now, obviously, I think it might inform him in the remedy phase, because what we have here is Google has been found guilty of being a monopoly and violating Section 2 of the Sherman Act. What that does not say is what the judge is going to do about it. That's a second trial. So this was just the liability phase, and now we're into the remedy phase. And in the remedy phase, Judge Mehta can do a bunch of different things. The kind of weak version of this would be to say, okay, instead of these exclusive deals, you have to put up a choice screen where at the beginning, when you open up your phone and when you open up your browser for the first time, it says, do you want to use Google or do you want to use Bing or DuckDuckGo or one of these other search engines? That would be a very weak version of this.
That would be weak because it has the same impact as, like, you know, we have a better product because we bought our way into buying all that data. I mean, people just are used to Google because they've done something illegal.
That's right. It allows that network effect to be perpetuated through this choice screen. Google is literally a verb. It's what you say when you want to look for information on the web. The idea that you're going to put that up in a choice screen, a neutral way against another product, it's not as neutral as you think. So other ways that this could be done is to eliminate these exclusive deals entirely. You could say, well, you're bundling this with Chrome and you have this relationship with Android. Maybe Google needs to actually divest of Chrome the browser, and divest of Android, the operating system for cell phones. And then competition can move freely between those different businesses. So that would be the stronger version of this. And obviously, the Justice Department has to make an ask. They have to say, this is what we want to come out of this conclusion. And then there'll be a trial of sorts, and then the judge will make a decision. Before that, it looks like Google's going to appeal this case. And so we are going to go into an appeals phase. I don't know how fast that's going to go.
But the remedy phase, my understanding is that the remedy phase and the appeal can be concurrent.
They can, but it's unclear whether Judge Mehta will say they should. He has the discretion to say, okay, I'm going to do the remedies while this works its way through the appeals phase in the courts. Or he could say, all right, let's do the appeals first. And then once they're extinguished, if we're back to a remedies phase, we'll do that then. So it's really up to him.
So there's actually like a full-on, almost like a trial for what we would normally consider like the sentencing hearing, essentially. So the DOJ, but this is a lot more complicated, obviously, because the DOJ is going to come in there not with like, here's the punishment, fine them, $10 billion or whatever it is. It is, we need to structure this in a way that will inhibit the ability of a monopoly taking hold in this sort of like sector of search, as it were. And we should say there's two other cases, or I should say there's one other case, I think, ongoing with Google, which we can mention in a second. But how important, well, first of all, what's your sense of how aggressive the DOJ will be in this instance? Because they could go in and say, just have that, option text box in the, or they could say, slice this company up in various ways. Don't allow for, people to purchase defaults, regardless of what the relationships are with Chrome and with Android. And how sophisticated, this seems to me almost the harder part of the remedy, almost seems like the more difficult thing for the DOJ to do, because you have a notion of like what constitutes a monopoly, right? Like this is like the Microsoft case, but the remedy, I would imagine, is in many ways sui generis.
It's a little tricky. I expect this Justice Department to be very aggressive. The fact that Google is paying $26 billion a year to be the default suggests that a monetary penalty is not going to do much here. They're already paying a monetary penalty of sorts every year in order to get this access. So you need a structural remedy here. And I think the DOJ understands that. Now, the important thing to talk about here is the fact that this DOJ is only in place for another 5 months. So the next administration is going to be new. It's going to be either Kamala Harris or it's going to be Donald Trump. And I don't expect the exact same makeup, regardless of who wins the next election. And the question that is at this point unanswered, although we have clues, is what is Kamala Harris's vision for what the next Justice Department, and in this particular case, the Justice Department Antitrust Division, look like? Because
all right, before we get to that, because we should say
analogy, but the reason I bring it up is that it's also very similar to the Microsoft case. Microsoft was found guilty under the Clinton administration. And then there were a series of appeals and there was a remedy phase, and that leaked into the Bush administration. And the Bush administration ended up doing a very weak settlement with Microsoft.
What?
Yes.
No. I'm shocked to hear that. Well, now, I think
you hear a lot of this idea that the trial is the remedy, and that is actually partially true. The fact that Microsoft was tied up for years in this antitrust case meant that they weren't feeling as bold to be, block everybody out of other parts of the tech industry, including the search market, which they could have done in 1999, 2000, where they could have blocked Google from being on Internet Explorer. And they didn't do that, and that led to the rise of Google. So it's important to note that I think just the fact that they've been found guilty of being a monopolist is going to have an impact. But in terms of an actual structural remedy, it's probably going to be up to the next administration just because of the timeline. And so when you ask me the question, it's very, it's difficult to say what that structural remedy will be. It's even more difficult because we don't know who's going to be making that decision.
And we should also say too, I mean, because I think there are some people out there who go like, the thing is government doesn't understand these things. There have been for months, if not years, lots of people and private and semi-private sort of forums and conferences about what the remedies would be for this specific thing. Never mind like even broader questions about the internet. So the ideas are out there. It's just a question of like, what, how they've been, and certainly you don't engage in this case if you're the DOJ and you're these people without having access to the people who might have ideas in which you begin to implement. I mean,
absolutely. I mean, there was, you mentioned entire conferences. There's a thing called Remedy Fest. That was an actual conference put on by Y Combinator, which is a kind of an incubator for startup tech firms, to look at what should the remedy be if Google is found guilty. And there was like a 2-day conference. Lena Khan was there. JD Vance was there at that conference. That's where he said, there's this quote where he said, Lena Khan is one of the few people doing a good job in the Biden administration. That was at Remedy Fest. That was at that conference. Jonathan Cantor was there. So there's absolutely strong indications from the people who would be affected by this. And they are startup entrepreneurs. We're all going to be affected by it, obviously, in terms of how we search. But these individuals have some ideas, and I think the DOJ has a bunch of ideas around this as well.
Okay, so let's. I mean, we've set the sort of the table. The remedy is going to be a function of how aggressive the DOJ is, and what the judge thinks of that. And then, of course, whether the DOJ that is going to be aggressive is actually the DOJ 7 months from now.
Right.
And presumably, if Donald Trump is the president, I would imagine there's a lot of people in the DOJ who start to like get some boxes and say, okay, time for me to move on type of situation. But the real question is Harris. I've got in front of me 2 pieces that have been written in the past couple of days, one by Zephyr Teachout and one by Matt Stoller, who just wrote it in the New York Times today.
Yeah.
Both, sort of make the same. I don't want to say they make a case as much as they say there's a question and we don't know. And that is, where will Harris fall on this spectrum? And I think we should say as a predicate, and I think you would agree with this, the Biden administration, between the FTC, the DOJ, and the Consumer Financial Protection Bureau, has been the most aggressive, anti-corporate, anti-neoliberal, at least in the perspective of this, certainly, and probably also in terms of trade and other things, administration of our short lives, you and I.
Presidencies aren't all one thing or all the other. I mean, you could talk about the rest of the Justice Department and show the sweetheart deals with Boeing and the fact that corporate crime prosecutions, criminal prosecutions are way down, even below Trump's level. You can
not to mention Trump and China. I mean, there's a lot of different things where they seem to have dropped the ball.
You can talk about these things in a context, but the faction that you're talking about, which seems to produce most of the things on the campaign trail as part of a record that Kamala Harris is touting is committed to a very aggressive form of antitrust enforcement, following the laws as they were written, and pursuing these cases in a very deliberate way. And so that absolutely is true, and we can stipulate.
Hey, folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.